Not loud enough for the bailiff to hear, not loud enough for the court reporter to catch, but loud enough for me. That little exhale through the nose, the corner of her lip curling up the same way it always did when she thought she'd already won something. Vivica turned to her new husband, Preston, and he shook his head slowly. The way you shake your head at something embarrassing, something sad. The way you look at a man who never quite figured out how the world works. I set my briefcase on the plaintiff's table and adjusted the collar of the same kind of suit I've been wearing for 23 years. Plain navy blue, no cufflinks, no pocket square. Nothing that announces itself. That's when Judge Harold Fenton walked in. He was a federal judge. 31 years on the bench. The kind of man who had seen everything and showed nothing. He sat down, lifted his glasses, and glanced at the papers in front of him. Then he looked up. His eyes found me at the table. And something happened to his face that I have not seen happen to Harold Fenton in 2 decades of knowing him. He went pale. His hand trembled on the edge of the bench. He leaned slightly forward like he couldn't trust his own eyesight, and in a courtroom that had gone momentarily still, I heard him whisper it. Just 4 words, barely audible. But I was close enough. Dear God, is that really him? Every head turned. Vivica's smile disappeared. Preston straightened up in his chair. Their attorney, a man named Douglas Pratt, who billed $600 an hour and had never once lost a custody modification in the Northern District, stopped shuffling his papers and looked at me for the first time. Really looked. They had no idea who I was, until they did. Before you hear the rest of this, I want to ask you to do something. If this story hits something real in you, if it says something you've needed to hear, please subscribe to this channel. Hit the like button. Leave a comment below telling me about a moment when someone underestimated you, when they counted you out before the game was even over. I read every single one. And now, let me take you back to the beginning. My name is Edmund Calloway. I am 49 years old. I work out of a building on Massachusetts Avenue in Washington, D.C., in an office that has no receptionist, no frosted glass logo on the door, and no name placard on the wall outside. Just a plain wooden door and a brass number. 14. If you know, you know. If you don't know, you're not supposed to be there. For 21 years before that office, I was a public defender in the D.C. circuit. Not the romantic Hollywood version of a public defender with the rumpled jacket and the passionate closing arguments. The real version. 92 cases at a time. Clients who couldn't remember your name. Judges who had already made up their minds. A salary that didn't cover my student loans. I did that work because I believed in it. I believed that the Constitution meant something, that the Sixth Amendment wasn't just words on paper, and that a man without money deserved the same quality of legal representation as a man with it. I still believe that. I always will. I met Vivica when we were both 26. She was working as an event coordinator at a firm in Bethesda, and I was the only person at a bar association mixer who didn't own a watch worth more than his car. She found that funny back then. She liked that I was different, she said. That I wasn't chasing it like all the other men she knew. That I cared about something real. We were married at a small venue in Alexandria. 37 guests. No live band, just a playlist we built together over 3 evenings of arguing about whether Springsteen belonged between dinner and dancing. He did. She conceded. Our daughter Nora was born 14 months later. For 11 years, I thought we were building something together. Not a monument, not a showcase, just a life. A real one. The kind with a grocery list on the fridge and Sunday morning arguments about whose turn it was to take the car for its oil change, and a daughter who made you feel like the most important person in any room she walked into. But Vivica had started wanting something different. I didn't see it happening because I wasn't looking. I was working. I was always working. I had a caseload that would have broken most people, and I wore that as a kind of pride I never should have been proud of. I confused dedication with presence. I thought because I was doing important work, I was being a good husband. I was wrong about that. Preston Ashby came into her life through a mutual friend at a charity auction. He was 40 at the time, owned a commercial real estate development company with offices in D.C. and Atlanta, and had the kind of easy, expensive confidence that comes from never once in your life wondering how you're going to cover a bill. He drove a car that cost more than my annual salary. He had memberships I'd never heard of. He took Vivica to places I'd been putting off taking her to for 11 years because there was always a case, always a client who needed something. I found out on a Thursday evening in February. Nora was at a sleepover. I came home to a house that smelled like someone else's cologne. She didn't even deny it. She sat down across from me at the kitchen table and told me she hadn't been happy in years, that she needed more. That she wasn't the person she was when we got married, and neither was I. She said it gently. That made it worse. When someone destroys your life gently, there's nothing to push back against. There's just the damage. The divorce was finalized 9 months later. I walked out of that courthouse with my clothes, my books, my daughter on alternating weekends, and a settlement that left me renting a one-bedroom apartment in Anacostia. Vivica got the house in Capitol Hill, the joint accounts, and child support that my salary barely covered. Her attorney was brilliant. Mine was overworked. Preston moved in within 3 months of the papers being signed. 6 months after that, they were engaged. Nora called me one Sunday morning, her voice careful and quiet the way children's voices get when they're carrying something too heavy for them. "Dad, Preston proposed to Mom last night." I sat in my apartment holding the phone, listening to my daughter's breathing, and I told her that was fine. That I was happy if her mom was happy, that I loved her and would see her Friday. I said all the right things. And then I sat there in the silence of that apartment, staring at the wall, and I made a decision. Not a revenge decision, not a rage decision, just a cold, clear, logical decision. I was done defending other people's futures while mine stood still. I had spent 21 years in courtrooms, and I knew something about the law that most people don't learn until it's too late. The law is not a system of fairness. It is a system of precision. The people who win are not always the people who are right. They are the people who understand exactly where the structure bends, where the language leaves room, where the precedents create doors that no one has thought to open yet. I had been walking through other people's doors my whole career. I had never built one of my own. I started writing. In the evenings after Nora went home, on Saturday mornings before the sun came up. I had been quietly obsessed for years with a narrow, difficult area of constitutional law involving Fourth Amendment protections and digital surveillance, a field that was exploding with litigation as technology had outrun the legal frameworks meant to govern it. I had been arguing these cases at the public defender's office for free on behalf of clients who couldn't pay me. I had won 7 of the 9 cases I'd taken to the appellate level. 2 of those decisions had been cited in opinions in other circuits. Nobody knew who I was. That was fine. I wasn't doing it to be known. I was doing it because I believed it. I published a law review article in the Georgetown Law Journal in the spring of the year my divorce was finalized. 6 months later, I got a call from a professor at Yale Law asking if I would come speak to a seminar. I almost didn't go because it was a weekend Nora was supposed to be with me. But she asked to stay with her school friend instead, and I drove to New Haven in my 2009 Honda Civic and gave a 2-hour talk to 14 students and 3 faculty members. One of those faculty members was a woman named Professor Diana Reyes, one of the most cited constitutional scholars in the country. After the talk, she pulled me aside and told me I was sitting on something seismic and that I needed to stop hiding it in a public defender's salary and write a book. I told her I couldn't afford to stop working. She told me she'd help me find a way. The book took 2.5 years. I wrote it in the mornings, the evenings, and every stolen hour I could find. It was called The Invisible Line: Digital Surveillance and the Dying Constitution. And when it was published by a university press in the year Nora turned 13, it landed in places I never expected. It was reviewed in 3 major law journals, cited in a Supreme Court amicus brief before the ink was dry, and within 6 months was being taught in law schools in 9 states. I never appeared on television. I never hired a publicist. I never changed the suit. What I did was start taking cases. Private cases by referral only. Cases where the constitutional questions were genuinely hard, where the stakes were enormous, and where the law was unsettled enough that the outcome could shape things for a generation. I turned down the corporate work because it bored me. I turned down the celebrity work because it embarrassed me. I took the cases where I thought the Constitution was actually in danger of losing something it couldn't get back. I won 11 of the first 12. The 12th I lost at the district level, appealed, and won at the circuit level 2 years later in a decision that was covered on the front page of the Washington Post above the fold. By the time Nora was 16, I had argued 3 cases before the Supreme Court of the United States. I had won 2 of them. The third produced a dissent from Justice Alana Graves that legal scholars were still debating in classrooms when the story I'm telling you today took place. I was not famous. I want to be clear about that. My name was not recognizable to ordinary people. I was not on the news. But in the world of federal courts, in the offices of circuit court judges, in the chambers of federal appellate benches, in every law school in this country where serious people argued about where the Constitution was heading, my name carried a weight that I had earned over 23 years of invisible work. I was still driving the 2009 Honda Civic. I was still wearing the plain navy suit, and I was still paying my child support check every month, without a single late payment for 12 years. The custody modification request came on a Tuesday. Nora was 20 years old, which meant she was not subject to a custody order anymore. She made her own choices. She chose to spend most of her time with me. This was not something Vivica and Preston had anticipated. Nora had applied to Georgetown Law. She had gotten in. She was going to start in the fall. She had also made the decision, entirely on her own, that she wanted to live with me during law school, which meant she would not be living in the house in Capitol Hill, which meant she would not be near her mother and Preston in the way they had come to expect. That wasn't what brought us to court. What brought us to court was money. A year before, my father had passed away. My father, Daniel Calloway, had lived frugally his entire life on a postal worker's salary in Baltimore. He had never owned anything flashy. He had driven a used car and worn his shoes until they had holes in them and spent his Friday evenings at his church. When he died, I discovered that he had quietly and patiently invested his savings for 40 years in index funds and government bonds, never touching the principal, letting it compound. He left me an estate worth a little over $3.2 million. I was as surprised as anyone. The will also included a direct bequest to Nora of $400,000, left to her in trust until her 21st birthday, with me named as the trustee. When Vivica's attorney filed the motion, the argument was that my financial circumstances had materially changed and that my child support obligations should be recalculated retroactively. They argued that because I was now the trustee of an asset worth $400,000 that would eventually go to Nora, I had a conflict of interest as trustee, and they wanted a court-appointed independent trustee installed with authority to make distributions for Nora's benefit, specifically for law school tuition, which they argued should come from the trust, rather than from Vivica and Preston's contributions. What they were actually doing was trying to get their hands on my father's money. That's the translation. They wanted to use the legal system to reposition assets that my father had worked his whole life to leave to his granddaughter and use them to reduce the financial obligations that Vivica and Preston had already planned to contribute. I read the motion at my kitchen table at midnight. I read it 3 times, and then I called Nora and told her not to worry about it. She asked if I needed her to do anything. I told her the only thing she needed to do was get ready for Georgetown Law School in September. I said I would take care of the rest. Douglas Pratt was a very good attorney. I want to say that clearly. He had a reputation in family and estate law that was genuinely earned, and he had chosen the strongest possible version of this argument and filed it with precision and confidence. When I walked into that courtroom, Pratt looked at me the way experienced attorneys look at people they've already decided aren't a threat. He glanced at my suit. He noted the absence of associates, of assistants, of any of the apparatus that a high-powered legal team typically brings into a federal courtroom to signal its seriousness. He made a calculation. He decided I was a man who had gotten lucky with an inheritance and thought he could handle his own legal affairs. Vivica made the same calculation. Preston made it faster. That is the thing about being invisible for 20 years. People see exactly what they expect to see. What they did not know, what they could not have known without doing the research that pride prevented them from doing, was that Harold Fenton and I had history. Not personal history, professional history. I had argued before him twice, including the surveillance case that had become something of a landmark decision, and I had been at a small working dinner 18 months prior, where he had told a room of 12 people that the invisible line brief I had filed in a Fourth Circuit matter was the most elegantly constructed piece of constitutional reasoning he had encountered in his 30 years on the federal bench. Harold Fenton was not a man who said things like that lightly. He was also not a man who forgot a face. When he walked in and saw me sitting at that table in that navy suit with no associates and no apparatus, He understood immediately what was about to happen. He understood that Douglas Pratt, who was very good, was about to be outmatched in a way that Pratt would not recognize until it was too late. And the weight of that understanding is what put the tremor in his hand and the color out of his face, and the whisper on his lips that turned every head in that courtroom. I will not walk you through every moment of that hearing because courts are slow and the law is technical, and most of what happens in a federal hearing is not dramatic. It is careful. It is methodical. It is the construction and dismantling of arguments piece by piece, with precision. But I will tell you the moment it turned. Pratt had been presenting his motion for 40 minutes. He was good. He had case law. He had precedent. He had 3 exhibits. And he had a very clean argument about trustee conflict of interest that was not frivolous. When it was my turn, I stood up. No notes. I had not brought notes because I did not need notes. I had been building this argument in my head since the night I read the motion, and I knew it the way I know my own apartment, every corner and every wall, every place where the floor creaks. I began by conceding the points I could not win. That is a technique most attorneys are afraid of, because it feels like weakness. It is not weakness. It is the removal of contested ground, so that the ground you choose to hold is the only ground that matters. I said, Your Honor, counsel is correct that a conflict of interest in a trustee relationship is a legitimate basis for court intervention. I do not dispute the legal framework he has cited. What I intend to demonstrate is that the conflict he alleges does not exist, and that the motion before this court is not, in its substance, a motion about trust administration. It is a motion about shifting the financial obligations of a prior divorce settlement from 2 parties who agreed to them to a trust belonging to a 20-year-old woman who asked for none of this. Fenton's pen stopped moving. Pratt looked up. I continued for 47 minutes. I did not raise my voice. I did not use dramatic pauses or rhetorical flourishes. I walked through the statute, through the precedents, through the specific language of the original divorce settlement and what it required of all parties. And then I did something that I could see Pratt had not prepared for. I introduced 3 affidavits from independent trustees in comparable matters, demonstrating the standard of practice in the district, and a brief I had submitted for Fenton's review 30 minutes before the hearing began. That laid out, in 23 pages, exactly why this motion, even if granted, would produce the opposite outcome from what petitioners intended under the specific terms of my father's will as interpreted under Maryland probate law. The motion was denied, not deferred, not modified. Denied. Fenton read 3 sentences from the bench. The 3rd sentence was this. Counsel for the respondent has demonstrated with clarity that the motion before this court, however competently filed, is at its foundation an attempt to relitigate settled financial obligations through the mechanism of trust administration, and this court will not permit that mechanism to be used in that manner. He did not look at Vivica when he said it. He did not need to. I want to tell you what happened in the corridor outside that courtroom, because it is the part of this story that still sits with me. Pratt found me by the elevator bank. He was professional about it. He was not hostile or defensive. He held out his hand and I shook it, and he said, Calloway, I should have done more research. I told him he had filed a strong motion and that a different set of facts would have made it a harder day for me. That was true. He nodded once and walked away. Preston did not come near me. He stood 30 feet away, his hands in the pockets of a suit that cost more than most people's car payments, and he looked at me with an expression I did not have a name for until I got home that evening and thought about it. It was not anger. It was not embarrassment exactly. It was the specific, disorienting experience of discovering that your model of the world is wrong about something important. He had looked at me for 11 years, and then for 12 more, and he had seen a man who didn't know how to win, who wore the wrong suit, who drove the wrong car, who had been passed over by the woman he loved and replaced by someone better equipped for the life she wanted. And none of that had been true. It had just been invisible. Viveka found me by the window at the end of the corridor. The Capitol dome was visible through the glass, the same view I'd looked at 10,000 times from 10,000 different government buildings over the course of my career. She stood next to me for a moment before she spoke. I didn't know, she said. I understood what she meant. She didn't mean she didn't know about the cases I had argued or the book I had written, or what it meant that Harold Fenton had gone pale when he walked in. She meant something simpler. She meant she hadn't understood what she had been married to. She hadn't recognized it, and by the time there might have been a moment to recognize it, she had already made her choices. I looked at her. 12 years since the kitchen table in Capitol Hill. 12 years since the plain admission with the gentle voice. She looked the same. She looked exactly the same, and I realized I felt nothing particular. Not triumph, not bitterness, not the warm relief I might have imagined in those early months after the divorce when I was eating frozen dinners alone in Anacostia and wondering what I was going to do with the rest of my life. Just nothing, clean and quiet. The way a room feels after you've finally removed the furniture that never belonged there. I told her that Nora was going to be extraordinary, that Georgetown law was going to challenge her and shape her and produce something remarkable, that she should be proud. That was all I said. I picked up my briefcase and I took the elevator down and I walked to my car. Nora started at Georgetown Law in September. I helped her move into her apartment 6 blocks from campus, 3 miles from my office on Massachusetts Avenue. On her first night there, we ordered Thai food and sat on the floor because the furniture hadn't arrived yet, and she asked me something I'd been wondering if she would ask. She asked me why I'd never told anyone, why I had never done anything with what I'd built to make myself visible, to make it obvious, to let the people who had written me off understand what they had gotten wrong. I thought about it for a long time before I answered. I told her that I had not built what I built to show anyone. I had built it because the work was important and because the Constitution deserved someone who treated it that way. I told her that the invisibility was not an accident. I told her that the most powerful force I had discovered in 23 years of practicing law was not intelligence or argument or precedent. It was patience, the willingness to do the work for the work's sake and let the results speak when they were ready. She was quiet for a moment. She picked up a piece of spring roll and looked at it for a second, and then looked at me. She said, "Is that really true? Or did you also just want to be the kind of person that people underestimated?" "She's going to be a very good lawyer." I told her yes. Both things were true. Because there is a particular kind of peace that comes from being the person in the room that no one has accounted for. There is a freedom in the plain navy suit and the 10-year-old car and the door with no name on it. Nobody asks you to perform. Nobody is watching. You can simply be what you are at full capacity for as long as you need to be, and when the moment comes, when it matters, you are not performing. You are simply yourself, and sometimes that is the most devastating thing you can be. My father used to say that there are 2 kinds of men who walk into a room, the kind who need the room to know they are there, and the kind who need only themselves to know it. He said the second kind is rarer and harder to become because it requires you to give up the need for constant confirmation that you are worth something. He worked for the post office for 37 years. He drove a used car. He wore his shoes until they had holes in them. He left his granddaughter $400,000 and his son a lesson I spent 20 years learning to receive. The money was never the point. The money was just evidence of what patience and purpose, compounded over time, can quietly build. Harold Fenton retired from the bench this past spring. At his retirement dinner, attended by 212 lawyers, judges, and former clerks, he gave a 20-minute address about the cases that had shaped his thinking over 31 years. He mentioned mine twice by name. He never mentioned the day in the courtroom. He didn't need to. Everyone in that room already knew. I sat in the back. Plain navy suit. Nobody needed to introduce me. The work introduces you. Eventually. Always. This is the ultimate proof that true power is silent. While Viveka and Preston were busy performing success with expensive suits and cars, Edmund was busy becoming the authority. They made the fatal mistake of confusing his modesty with failure. The moment the judge whispered, "Is that really him?" the power dynamic shifted forever. Edmund didn't win because of his inheritance. He won because he spent 20 years mastering the system they tried to use against him. He didn't just win a case, he destroyed their entire worldview. The takeaway? There is a massive advantage in being underestimated. Don't waste energy trying to look important. Do the work that makes you essential. Edmund Callaway didn't need to announce himself. His reputation did the talking for him.